And we are hosting this as a collaborative effort amongst the three of us, the Department of Political Studies, the Finnish National Pugwash Group, and the South African National Pugwash Group. And I see my colleague, Katarina. We don't see you on the screen, but I do see you in the audience. So I think Katarina, can you I'll ask Melody if you can just send Katarina a panelist. There we go. So Katarina, I'm going to hand over to Katarina Simonen from the Finnish Pugwash Group and to say a few words about what Pugwash is.
Hi, yes, with pleasure. Now I control the functions. Greetings to you all, colleagues and friends, and it's a pleasure to be here with you. And thank you for South African Pugwash and the university for taking this initiative. So what is Pugwash? It's a network of high-level scientists and policymakers who strive to promote disarmament, non-proliferation of weapons of mass destruction, and peaceful resolution of conflicts. Pugwash roots lie in the nuclear arms race of the late 1950s. In 1955, eminent scientists such as Albert Einstein, they signed the so-called Russell-Einstein Manifesto, which paved way for the first meeting of scientists in the village of Pugwash, Nova Scotia in Canada. Since then, scientists and also policymakers later on from across the divides would meet regularly to exchange ideas for arms control and disarmament. This is science diplomacy behind the scenes. And shortly, Pugwash has played a significant role in the shaping of key arms control treaties during the history. And Pugwash received a Nobel Peace Prize in 1955 for its efforts to diminish the part played by nuclear arms in international politics and in the longer run to eliminate such arms. So this is Pugwash in a nutshell. Thank you.
Thanks so much, Katarina. I would like to preface our discussions today by saying that the topic, Israel's response to the 7 October attacks in the context of international law, is not an easy one to broach. The leeway that scholars have within their countries, their institutions, and their communities to speak freely on this topic is not guaranteed. So when we conceptualize today's program around the three questions, is it anti-Semitic to criticize Israel's response? Is the relationship between Israel and Palestine one of apartheid? And is Israel's response with respect to Gaza after the 7 October attacks genocide? We identified three scholars who could expand our understanding and our awareness around these three questions based on their extensive academic knowledge and previous work in, for example, the areas of refugees, human rights, democracy, and international law. And they bring this to our deliberations today. So I'm really grateful that our speakers agreed to give so generously of their time and expertise today. I also want to note that our speakers are here in the individual capacities as academic experts. They're not representatives of their countries or their academic affiliations in that sense. I will give each speaker 20 minutes to speak. And as you've probably heard when we deliberated this before, we will have questions and answers at the end of the three speakers' talks. Participants can post questions in the Q&A box. I'll ask you to please keep your questions or comments concise, and please indicate which speaker you would like to respond to your comment or to your question. So with that, I'd like to introduce Professor Stephen Friedman, who for the South Africans in the audience is no stranger. Professor Friedman a well-known analyst of South African politics, is regularly on the television. He's a research professor in the Faculty of Humanities at the University of Johannesburg. He has published several studies of South Africa's transition to democracy, and his current work focuses on the theory and practice of democracy. He's the author of several books, numerous book chapters and journal articles. And his most recent book is called Good Jew, Bad Jew, Racism, Anti-Semitism, and the Assault on Meaning. So Professor Friedman, with that, I'll hand over to you.
Yeah, thanks for the opportunity. I mean, what I'm going to say is mainly based on the book that was published about a year ago, which is precisely on the way in which the meaning of anti-racism and the meaning of anti-Semitism has changed as a result of the efforts of the Israeli state and its allies in Western Europe and North America. But to put this in context for people around the world, it's very important to stress that at the moment, liberal democratic freedoms in Western countries, in many Western countries, not in all, are being substantially eroded by repression and attempts to silence people who are critical of the Israeli state and sympathetic to the plight of the Palestinian people. In the United States, the Trump administration, when it takes over in January, may well adopt a document called Project Esther, developed by the Heritage Foundation, which is in effect a plan for the total suppression of speech which is sympathetic to Palestinians. It looks very much like the McCarthyism of the 1950s. The document refers very approvingly to McCarthyism and the way in which it terrorized people for holding particular political views. And the reason I'm drawing attention to all of this is that all of these attempts to clamp down on democratic freedoms which have been taken for granted for generations is being justified in the name of an attack on anti-Semitism. So that throughout the Project Esther document, we're told that what they're actually doing is they're fighting anti-Semitism. And anti-Semitism, of course, is the term that has historically been used for prejudice against Jewish people. It's not a very good term because Jews are not the only people of Semitic extraction. The British scholar Avi Shlaim at Oxford suggests that we really should be talking about anti-Jewish racism rather than anti-Semitism. And he's right, but I still use the term anti-Semitism. And the reason I still use the term anti-Semitism is that the prejudice may be anti-Jewish racism, but the weapon which is used to justify racism by the Israeli state is anti-Semitism. So in other words, anti-Semitism has become a weapon which is used against people who are opposed to the treatment of Palestinians by the Israeli state, which of course is a great irony because people who are opposed to this are anti-racists. They are opposed to what the Israeli state is doing because what the Israeli state is doing is racist. In 2019, in case there was any doubt about it, the Israeli parliament passed a law called the Nation State Law, which declares very explicitly that the state of Israel is for one ethnic group only in a context in which other ethnic groups occupy the same territory, so that it is no different to the kind of apartheid which was introduced in this country or racially discriminatory legislation anywhere else. But what the supporters of the Israeli state, which includes most of the major Western countries, insist on doing is demonizing people who are opposed to this racism by labeling them as anti-Semites. Now, how did this come about? First of all, a couple of words on what anti-Semitism really is. Anti-Semitism, if you go back to the 19th century, prejudice against Jewish people was originally justified on religious grounds because of their faith was considered unacceptable, etc. But secularism and the Enlightenment ensured that that began to lose credibility. And in reaction to the extension of democratic freedoms to Western countries, which applied to Jews as well, in the late 19th century, some writers in Germany, in fact, coined the term anti-Semitism because they said, no, the problem with Jews was not their religion. The problem with Jews was that Jews were a race, and a race which was threatening Western civilization. And it's also important to bear in mind, for something I'm going to say in a moment, that inevitably, and I know of no exceptions, people who express this hatred towards Jews, this racial hatred towards Jews, didn't stop at Jews. They harbored very ugly prejudices against other people as well. Houston Stewart Chamberlain, who was perhaps the man who claimed to have invented the science of anti-Semitism. He was in fact British, but he lived in Germany and married the daughter of the composer Richard Wagner. Chamberlain sent a letter of congratulation to the German Kaiser in the early 1900s because the German state was then conducting a genocide against the Herero and Nama people of Namibia. And Chamberlain congratulated the Kaiser on the mass murder, in effect, of Namibians, because, of course, those Namibians were black, and in Chamberlain's view, that made them inferior. He was also threatened by Chinese people and other followers of his particular view of the world have tended to be bigoted against Asian people, lately against Muslims, etc. So there's a package of prejudices there, of which anti-Semitism was one. All this began to change when Zionism emerged as an ideology. Zionism is the ideology which underpins the Israeli state, and it was the creation of particularly Austrian and Russian thinkers, Jewish thinkers, and in a sense, Zionism presented itself as if you like, I've heard it described as the national liberation ideology of the Jewish people. So, in other words, what we're supposed to think about Zionism is that it is an expression of Jewish pride. It is a reaction to anti-Semitism. It is, if you like it, for South Africans, a Jewish version of Black consciousness. Now, what I show in the book is that nothing could be further from the truth. Zionism is not an expression of Jewish pride at all. In fact, the Zionist writers thoroughly disliked Jews. Theodor Herzl, who is still revered by the Zionist movement, insisted that the anti-Semites of the time were right, that Jews were very grubby, parasitic people. And A.D. Gordon, a revered labor Zionist, referred to Jews as parasites. The difference between them and the anti-Semites was that the anti-Semites said that Jews were doomed to be like this forever, But the Zionists said, no, the reason Jews were as awful as they were was that they didn't have a state. And as soon as Jews had a state, they would be like everybody else. And that begs the question of who everybody else was, because that's key to my argument. And who everybody else was not the rest of humanity. Everybody else was white Western Europeans. It's obvious both for the context of Herzl's writings, of that of Sigmund Freud, the psychologist who was also a Zionist thinker at the time, that they didn't want to be accepted by the rest of humanity. They wanted to be accepted by white Western Europe. And Zionism was an attempt to ensure that Jews who for many years had lived in Europe, had been, if you like, in Europe, but not of Europe, in the sense that they were not accepted by European elites, but were living in Europe. Zionism, it was believed, would make them acceptable to white Western Europeans. And in that, Zionism has succeeded. Zionism has succeeded in making some Jews acceptable to white Western Europe. And we see the results today. Those attempts to suppress pro-Palestinian speech, which I talked about earlier, are there precisely because the Western elites believe that the Israeli state, which Zionism created, is an expression of Westernness in an area which is not Western. What the Zionists promised their fellow Jews in Europe was that Zionism would cure anti-Jewish prejudice. In other words, that if Jews had a state, like everyone else being other white Western Europeans, then there would be no anti-Semitism directed at Jews. Well, they got it half right, in the sense that, as I've indicated, the effect of creating the state was to make sure that they won acceptance in white Western Europe. Obviously, that acceptance process was helped by the Nazi genocide, the Nazi slaughter of 6 million Jews, together with millions of other people, because that seemed to illustrate the point that Jews needed a state. That was the way which is interpreted, although the logic doesn't really work. But the Jews became accepted by white Western Europe. What it didn't do is persuade Palestinians that they should lose their land. So although the creation of the state persuaded elites in Western Europe that Jews were acceptable as long as they were Zionist Jews, it didn't convince Palestinians that they should give up their land and their homes in order to atone for the sins of Nazi Germany. And therefore, it became clear that creating a state did not create a situation in which everybody loved Zionist Jews. And the response of the Israeli state to all of this was to change the argument. So instead of saying that Zionism was the cure for anti-Semitism, they insisted that Zionism was a cause of anti-Semitism, because some people so hated Jews that even when they had a state, they would be subject to prejudice. But what quickly became clear is that the target of the prejudice that they were labeling anti-Semitism, that they were acting to, the target was not Jewish people. The target was a particular state and its actions. And essentially what they tried to do is pass off the state as the embodiment of Jewish people. And that is not a very democratic idea. In fact, it's a deeply scary idea. There's a British academic who's been working on anti-Semitism for years called Anthony Lerman. And Lerman published a book around about the same time as my book was published called Whatever Happened to Anti-Semitism. And a lot of Lerman's book is devoted to debunking the claim that the state of Israel is somehow equivalent to a Jewish person. So that if you're prejudiced against the state of Israel, you're also prejudiced against Jewish people. And as Stephanie Fox, who is the head of the Jewish Voice for Peace organization in the United States, has pointed out, the state of Israel is not a Jew. The state of Israel is a state. And like any other state, it's accountable to international law, international humanitarian law, and to United Nations statutes outlawing apartheid. And this particular change of approach by the Israeli state spawned a cottage industry in the United States of authors who decried the new anti-Semitism. And the difference between the new anti-Semitism and the old anti-Semitism was that the new anti-Semitism was not hostility towards Jewish people, it was hostility towards a state. And if you read the writings of the new anti-Semitism writers, they become quite bizarre in places. In their view, it is anti-Semitic to be in favor of, it's anti-Semitic to be against nuclear energy, and it is anti-Semitic to criticize the Electoral College in the United States. Why? Because at the time in which they were writing this, the Israeli state's biggest problem was neighboring states who relied on oil revenues. And if you oppose nuclear power, then you were opposing an alternative to oil, and you were opposing something which would make it easier, would weaken neighboring states and would strengthen the Israeli state. The Electoral College, they believe, not necessarily actually, gave Zionist Jews power in American elections, which enabled them to be heard whatever the majority wanted, and therefore to be critical of the Electoral College is also to be anti-Semitic. Well, it's quite obvious. I mean, all of this is obviously nonsense. None of it bears any intellectual scrutiny at all. But essentially what they're doing is substituting opposition to a state for racism. And they're saying that if you're opposed to a state and its actions, then you're racist. And obviously, as a South African, the most obvious comparison, if it's necessary to indicate the weakness of this sort of argument, is that, in effect, what it would mean is that every South African who opposed apartheid in the apartheid state hated white people. And clearly that is not a tenable argument. But we are living with the results of that today, because what has happened, particularly in Western Europe and North America, is that anti-Semitism, which used to be a form of racism, has now changed its meaning entirely. Anti-Semitism no longer means racism directed at Jewish people. What anti-Semitism actually does mean is opposition to the Israeli state and opposition to those Western elites who support the Israeli state. Now, this operates throughout Western Europe, but there's no state in which it operates more clearly than in Germany, in which anti-Semitism is used as a code for racism directed at Muslim people and at people of Palestinian extraction. So you'll hear German politicians, for example, say, we've got to reduce immigration because that imports anti-Semitism. And where does it import anti-Semitism? Well, it obviously means that if you allow Muslim people to live in your country, they're all anti-Semites, and therefore you need to expel. So I'm about out of time now, but the point that I want to make, the point that I want to reiterate from this brief summary of how we got here, is that it's very important to understand at the moment that far more is at stake here than the illegitimate claim that if you're opposed to the actions of a state, if you're an anti-racist opponent of the state, then you are an anti-Semite. I should mention, which I didn't mention before, which is very important to the argument, The group of people who are most likely to be accused of anti-Semitism and to have their civil liberties infringed because they're anti-Semitic are Jewish people. If you look at the British Labour Party, which conducted a witch hunt against people who were so-called engaged in anti-Semitism, they were really people who simply supported Palestinian rights. One group within the British Labour Party calculated that if you were a Jewish member of the British Labour Party, you were 20 times more likely to be expelled for anti-Semitism than if you were not Jewish. And this has to do, obviously, with the fact that Jewish people are far more invested in the whole issue of Palestine, and many Jewish people find what's happening to the Palestinian people to be entirely unacceptable. So it is entirely spurious, but more is involved than that. And the more that is involved is that right now, in key Western countries, the spurious use of anti-Semitism, this change in terminology in which what was once an ugly form of racism is now criticism of the West, criticism of Western governments, that this is actually being used to erode the democratic freedoms which Western Europeans and Americans have taken for granted for decades. So not only is this use of anti-Semitism spurious, it is actually a clear and present threat to democracy's survival in the West at the moment. Thank you very much for your patience. I hope I haven't exceeded my time by 2 minutes.
No, thank you so much, Prof. So our next speaker on the panel is Professor Victor Catan. I hope I'm pronouncing that correctly. He is an assistant professor in public international law at the University of Nottingham School of Law, where he is the Deputy Director of the Nottingham International Law and Security Centre. His recent publications include an edited book with Brian Cuddy titled Making Endless War, the Vietnam and Arab-Israeli Conflicts in the History of International Law. And he's also editor with Amit Ranjan of The Breakup of India and Palestine, the Causes and Legacies of Partition. So thank you so much. The floor is yours.
Thank you very much, Professor Pretorius. And I'd like to begin by thanking the South African and Finnish national pugwash groups and the University of the Western Cape for the invitation. So the question that I've been asked to address is whether Israel's crimes against the Palestinians constitute apartheid. And I note that my friend and colleague, Professor Susan Akram, who is speaking after me, will be addressing whether Israel's actions in Gaza constitute genocide. So before I get into the details of apartheid, some of you may be wondering whether Israel's policies can amount to both apartheid and genocide. And I would venture to answer, without encroaching on Professor Akram's talk, that they can be both, and that there is in fact an overlap between the definitions of the crime against humanity of apartheid and the crime of genocide. But whereas genocide, if you like, comes towards the end of a process of dehumanization, apartheid describes the institutional or structural context that may or may not lead to genocide. So while there is an overlap between the crimes, logically apartheid comes before genocide. Hence, it makes sense for me to speak before Professor Akram. So in my brief remarks, I want to address 3 issues. I'm going to, because I'm at a law school, I will talk about the legal definition of apartheid as a crime against humanity. And then in that context, I will talk about recent developments at the International Criminal Court and also at the International Court of Justice, which is the other court in The Hague, which delivered an advisory opinion earlier this year, which touched on the prohibition of apartheid, and I'll discuss how that's relevant. And then I will also have a brief comment on the how the nation's state law, and Professor Friedman briefly mentioned, has ironically made it more acceptable to talk about apartheid in Israel, Palestine, in fact, even to talk about apartheid in Israel, and not just the West Bank. And then I'll conclude with some words, some remarks about the new settlement administration, that has been established in the West Bank over the summer, and how this administration furthers the already existing institutionalized discrimination and domination that Israel practices against the Palestinians. So let me begin with the law, and particularly international law. So under both the 1973 International Convention on the Suppression and Punishment of the Crime of Apartheid and the 1998 Rome Statutes of the International Criminal Court, apartheid is defined as a crime against humanity associated with a structure of government in which a superior racial group establishes a system that oppresses and dominates an inferior one. And in order to ensure the maintenance of this oppressive system, multiple inhuman or inhumane acts are perpetrated. So whereas the 1973 Apartheid Convention was very much modeled on Southern Africa, the situation in South Africa, Namibia, and Rhodesia, the Rome Statute was not, because the Rome Statute was adopted in 1998 after apartheid had ended, or formal apartheid, the system that existed in South Africa from 1948 to 1995 had ended. So in contrast to the earlier Convention on Apartheid, the Rome Statute doesn't expressly refer to policies and practices in Southern Africa. So it tries to adopt what they call an objective definition, although it does use similar language. For example, it refers to racial groups, which had a specific meaning in South Africa during the apartheid era. Now, both of these conventions, the 1973 Apartheid Convention and the 1998 Rome Statute, are widely ratified treaties. So what this means is that they are binding not just at the international level, but also at the domestic level in respect of those states that have adopted domestic legislation giving effect to their obligations under these treaties. So the Apartheid Convention has 110 states parties, mostly global South states. I note that the Republic of South Africa acceded to the convention in May of this year, though my understanding is it hasn't yet adopted implementing legislation. It'll be interesting to see how they try and do that. The Rome Statute has 124 states parties, including significantly many states that had not become party to the 1973 Apartheid Convention. So notably, 167 states out of 193 members of the United Nations have ratified at least one of these treaties. So that's a very large number of countries, and I'll explain why that's significant. But before I do so, I want to state the obvious point. Israel is not party to either of these conventions. Palestine is party to both of them. But what's significant is that even though Israel is not a party to these conventions, it is nonetheless bound by its provisions to the extent to which they reflect customary international law. So what that means in layperson's terms is if there's an international consensus beyond the fact that states have ratified a treaty, that can still bind a country, even if they're not party to the treaties. And so I would argue, given the wide number of states, the variety of states from all parts of the world, not just the global South, but also the global North, there is a consensus, a widespread consensus, that apartheid as a crime against humanity is customary international law. Now I'm going to turn to the ICC. In any event, even if that argument was not accepted, the fact is that the International Criminal Court has jurisdiction to examine the crime in regard to the territory of the state of Palestine. That's East Jerusalem, the West Bank, and Gaza, which is under occupation by the government of Israel. So even if even if you were not to accept my argument that it is customary international law, conventionally, Palestine being party to the Rome Statute gives that court jurisdiction to examine the crime. And I note in this regard, just last week, that the prosecutor of the International Criminal Court, Karim Khan, when he was explaining the basis for the issuance of arrest warrants, which were approved of by the pre-trial chamber against Prime Minister Netanyahu and the former defense minister, said that his office, and I quote, is taking forward additional lines of inquiry in areas under the court's jurisdiction, which include Gaza and the West Bank, including East Jerusalem. So while arrest warrants have not yet been requested regarding crimes in the West Bank, it's clearly something that was in the purview of the office of the prosecutor. We don't know if they're looking at the crime of apartheid, but I would note that Palestine explicitly raised this crime in its state referral back in 2018. It was also raised in a later referral to the International Criminal Court by South Africa, Bangladesh, Bolivia, the Comoros, and Djibouti. So they raised actually just last year. So we'll have to wait for an announcement to see if, firstly, whether any more warrants will be requested for crimes in the West Bank, and if those warrants are requested, whether they will include the crime of apartheid. Now, as regards the other international court in The Hague, the International Court of Justice, which doesn't deal with crimes as such, but with breaches of international law by states at the international level, it's worth noting that on the 19th of July, they delivered an advisory opinion on the illegality of Israel's presence in the occupied territory, the illegality of its occupation. And in that context, they found a breach of Article 3 of the 1965 International Convention on the Elimination of All Forms of Racial Discrimination, which prohibits all practices of racial segregation and apartheid. Now, while it's true that the court didn't go into a huge amount of detail, they didn't use the word apartheid in the opinion, except for when they mentioned the breach of Article 3. They did use this curious expression, systemic discrimination. And that word, systemic discrimination, that doesn't actually appear in any of the treaties that they cited on non-discrimination. And for me, it feels, when I was reading the opinion, that they were using the word systemic discrimination as a synonym or an alternative word for apartheid. So it seems that there may have been a division of views. Maybe they thought the word apartheid was controversial. One of the judges, in a separate opinion, said some judges were uncomfortable using a word that was so closely associated with Southern Africa in a different context. So, but when you read the opinion, you read what the court said about discrimination, they are describing an institutionalized system where there is mass discrimination and domination and mass violations of human rights. It reads as though it's describing an apartheid system in all but name. Just to give you some of the examples. So they referred to a number of policies that were discriminatory, that affected Palestinian residency, construction, access to water, natural resources, restrictions on freedom of movement, employment, and occupation. So they gave the example of restrictions on the exploitation of natural resources by Palestinian enterprises in Areas C. For example, quarrying. All the companies that are quarrying in the West Bank, 95% of them are Israeli companies. Not so different, I guess, to the number of white-owned farms and the mining industry in South Africa during the apartheid era. Maybe it's still the same. I don't know. But they also referred to discriminatory legislation, that affects, for example, family reunification between Palestinians who hold different ID cards or different citizenship. So there's a distinction between Palestinians in the West Bank, Palestinians in East Jerusalem, and Palestinian citizens of Israel, which is done through an elaborate ID card and permit system, which not too different from the Donbass, the cards people used to have to carry in South Africa. And then there's territorial fragmentation, which is not so different to, I guess, the Bantustan model, although it's more extreme in the West Bank, smaller. It's carved out into military zones. There's massive restrictions on freedom of movement that's done on racial grounds or national grounds, identity grounds, let's say, religious grounds. There's a bit of a difference in the law the ID card system makes Israeli legislation and Israeli ID card system makes a very clear distinction between persons of Jewish origin, the Jewish faith, and those who are not Jews. So you get a different class in your ID card that affects the kind of work you can do, where you can travel, etc. And then the International Court of Justice even referred to what it called the use of disproportionate force against peaceful Palestinian protests in its advisory opinion, which is not too different to what happened in Sharpeville and Soweto. And quote, it referred to the maintenance of a coercive environment against Palestinians. And I note in this regard that the South African judge, Judge Dire Tladi, said, and I'm quoting him here, if we compare the policies of the South African apartheid regime with the practices of Israel in the occupied territory, Palestinian territories, it is impossible not to come to the conclusion that they are similar, end quotes. And as a black South African who himself grew up in a Bantustan, which he expressly mentions in his separate opinion, I would suggest he knows what he's talking about. Okay, now I'm going to turn to the impact of the nation-state law. So this was a law that was adopted by the Knesset, Israel's legislature, in the year 2018. And it provides for a number of issues, but one of the most egregious statements is the following, when it provides that the exercise of the right to national self-determination in the state of Israel is exclusive to the Jewish people. Note the word exclusive and bear in mind the historical context that Palestine historically was a majority Palestinian, that it continues to have a huge Palestinian non-Jewish population. This emphasis on exclusivity is particularly discriminatory. And we should also bear in mind the current coalition government in Israel defines what they call the land of Israel as including what they call Judea and Samaria, that is the West Bank. So they claim sovereignty from the Mediterranean Sea to the Jordan River. They claim full sovereignty, and they claim that they have a right, the Jewish people have an exclusive right to national self-determination over all of that territory. Now, the effect of this law has been profound. So while the law actually didn't change anything significantly inside Israel, because it already reflected the prevailing legal situation in the country, that there was already the case that the law discriminated between Jews and non-Jews, having stated it so categorically in a constitutional statute, made it plain for the world to see that Israel was a state that practices institutionalized systemic discrimination, a finding that has since been endorsed by the principal judicial organ of the United Nations. Now, it's striking to recall in this regard that in the year 2017, so that is a year before the Knesset passed the nation-state law, two professors, that is Professor Virginia Tilley and Professor Richard Falk, had published a report for one of the United Nations organs about apartheid in Israel-Palestine, and it created such a furore that the UN Secretary General demanded that they remove the report from the website of the United Nations. A year later, the nation-state law is adopted. 2 years after the nation-state law, we had a flurry of blue-chip international human rights organizations, Human Rights Watch, Amnesty International, as well as Israeli NGOs, B'Tselem, Yesh Din, Palestinian NGOs such as Al-Haq, also publishing studies endorsing the claim that Israel's policies and practices towards the Palestinian people amounted to apartheid. So that 2018 was a key year. It made it more acceptable to articulate this claim, even though fundamentally nothing radical had changed. I mean, Israeli politics became more extreme, but the actual discrimination in the West Bank was not that different to what existed before. So to conclude, one issue I want to mention before I conclude is a recent development that over the last few months, and that is the establishment of a new settlement administration in the West Bank that is headed by Bezalel Smotrich, who's Israel's finance minister and the additional minister of defense. And this is a significant change because this new body, if you like, it is now administering the military government that part of the military government in the West Bank that deals with civil affairs. So we no longer have a situation in the West Bank that is just being run by the military. We also have a civilian unit doing the work. This kind of points towards the fact that the situation in the West Bank is already de jure and not just de facto annexation. And I note that the Settlement Administration has the power to enact new regulations, as well as to retroactively authorize settler outposts without government approval on private Palestinian land. Now, in this context, we should bear in mind that Israeli legislation in the West Bank, which is channeled through military orders, already discriminates between Palestinians and Israeli settlers. Whereas Israeli settlers are subject to the laws of Israel with all the civil rights that gives them, these same rights are expressly denied to Palestinians living in the same territory. And in this context, we should bear in mind the views of Minister Smotrich. And I'll just quote a sentence he gave before he became the minister. And he said that part of his long-term plans for the West Bank was that he wanted to impose Israeli sovereignty on all the territories of Judea and Samaria, that is the West Bank. And I'm quoting him, without granting the Arabs, doesn't even use the word Palestinians, living there, the right to vote for the Knesset and still remain a democracy, end quote. And according to Israeli press reports, it has been estimated that since the year 2018, that is the year the Knesset adopted the nation-state law, there have been more Palestinian Arabs living between the Jordan River and the Mediterranean Sea than Jewish Israelis. So to conclude, all the ingredients of apartheid, racially discriminatory laws and policies, a system of domination and inhumane acts, mass arrests, killings, torture, arbitrary detention, etc., they are all there. Going forward, we will have to see how the United Nations political organs respond to these events. And in this regard, I note recent initiatives in the UN General Assembly to create a new anti-apartheid committee modeled on the former one that had been created to combat apartheid in South Africa. And it remains to be seen how successful these endeavors will be. Thank you very much for listening.
Thank you so much, Prof. Gatan. So our last speaker is Professor Susan Akram, who's from Boston University's Law School, where she directs the International Human Rights Clinic, and she supervises students engaged in international advocacy in domestic, international, regional, and United Nations fora. Her research and publications focus on immigration, asylum, refugees, forced migration, and human and civil rights issues, with an interest in the Middle East and Arab and Muslim world. She's lectured on Palestinian refugees to general audiences around the world, as well as to committees of the United Nations, the European Union, and representatives of the European and Canadian government ministries and parliaments. And a recent book by her is co-authored with Dina Hurwitz is titled Teaching Human Rights, Practice and Theory. So Prof. Akram, I look forward to your talk on Is This a Genocide?
Thank you so much, Professor Pretorius, and it's also a great pleasure to be on this program to talk about these really essential issues. So the last question, and the one I'm tasked to answer, is this a genocide? So genocide is amongst the gravest of international crimes that include crimes against humanity, aggression, and war crimes. And as Professor Gatan noted, genocide is defined in the 1948 Genocide Convention, which has been ratified by 153 states, as well as in the Rome Statute of the International Criminal Court, ratified by 124 states. Now, the definition of genocide is essentially the same in both treaties. It's the intentional destruction, in whole or in part, of any national, ethnic, racial, or religious group through specific acts. And these acts are killing members of the group, causing serious bodily or mental harm, deliberately inflicting conditions of life designed to bring about the group's physical destruction, and imposing measures intended to prevent births or forcibly transferring children of this group to another group. Now, I should note that it is not required to satisfy every one of these acts, but it is sufficient if one of these acts is carried out with the requisite intent. And there are two important points to make at the outset about genocide as a universal crime. First of all, it is what is called a jus cogens prohibition, meaning that no state can derogate from it or suspend its application for any reason. And second, genocide triggers what are called erga omnes obligations, that is, obligations on all states to act to prevent, and I note prevent, as well as punish genocide crimes. Now, based on its obligations under the Genocide Convention, South Africa's case filed in December of 2023 in the International Court of Justice, the ICJ, claims that Israel's prosecution of its war on Gaza amounts to genocide. After extensive pleadings and oral arguments, the ICJ issued provisional measures against Israel 3 times, on January 26th, March 28th, and May 24th of this year. Provisional measures are akin to what in national courts are called preliminary injunctions. They're issued on the basis of a preliminary or prima facie finding before a full hearing on the merits of the claim. Now, in its 3 provisional measures, the ICJ found it plausible that Israel is committing genocidal acts and that certain elements of the Genocide Convention have been met. It has ordered Israel to cease and to stop its military from engaging in acts against Palestinians in Gaza, including killing, causing serious bodily or mental harm, deliberately inflicting conditions of life calculated to bring about the physical destruction of Palestinians. It also ordered Israel to stop direct and public incitement of genocide and to urgently take all measures to allow basic services and humanitarian assistance to enter Gaza necessary for Palestinians' survival. In its last 2 orders, the ICJ required Israel to immediately and unconditionally open all border crossings and allow unlimited humanitarian aid to Gaza, including food, water, fuel, medical, and other necessities. And finally, in its last order, to immediately halt its military offensive in Rafah, open the Rafah crossing for unhindered aid, and allow access to Gaza of an investigative body to determine the evidence of genocide. To date, as I'm sure you all know, Israel has ignored the ICJ's orders. I'm going to discuss some of the evidence raised in the claims to the ICJ and the evidence that my clinic and 5 other clinics and human rights centers reviewed in our report on genocide in May. The crime of genocide, as Professor Katan noted, sits alongside other major international crimes, and genocidal acts, genocidal intent, and other elements take into consideration related crimes and prohibitions found in international human rights, international humanitarian, and international criminal law. In determining both intent to commit and whether the acts committed carry out genocidal intent, humanitarian law principles have to be examined. Israel claims its attack on Gaza is in self-defense for Hamas and other militants' attacks on southern Israel on October 7th, and that its war is against Hamas and not the Palestinian people. But with regard to genocide, as I mentioned, there's no excuse or defense for it. Neither retaliation nor revenge are excuses for committing genocidal acts. Under humanitarian law, there are additional considerations in determining whether the means of warfare are legitimate. There are restrictions and prohibitions on how an armed conflict can be carried out. These are codified in the 4 Geneva Conventions of 1949. The principal rules are of distinction, proportionality, and precaution. These are intended to ensure that minimal harm and protection of civilians is ensured during the carryout of any armed conflict. Targeting civilians and civilian objects, causing harm to civilians beyond military necessity, failing to take all precautions to protect civilians, and imposing punitive sieges all fail these principles and are war crimes. Violating these principles can also be evidence that the aim is not self-defense, but genocidal acts. We'll look briefly, I'll just give an overview of the evidence next, beginning with the element of intent. Genocide is often claimed by scholars to be a process and not an event. The process of dehumanization of Palestinians by Israelis began long before 2023. Israelis at the highest level of government have used language dehumanizing Palestinians and expressing the intent to indiscriminately punish and destroy them. This dehumanization began with the Zionist and Israeli founders, from Golda Meir to Moshe Dayan to Ariel Sharon. South Africa's initial application has 8 full pages of racist, dehumanizing, and exterminating statements by Israeli politicians, spokespersons, government officials, and media at every level of society that indicate genocidal intent, as well as the intent to carry out genocidal aims. These include, most recently, the famous statement of the Prime Minister on 28 October 2023, invoking the biblical story of Amalek by the Israelites, which exhorts sparing no one, killing men, women, children, and cattle. Among the dozens upon dozens of statements from high officials indicating genocidal intent are National Security Minister Ben-Gvir's statement that all supporters of Hamas, including children, need to be eliminated. Major General Alian's statement that Gazans are human animals and will get hell and be destroyed, and former Defense Minister Gallant's statement on 9th October that there would be no electricity, no food, no water, no fuel for Gazans, as they are human animals. To be considered genocide, the purpose of the acts must be to kill members of the group and to be sufficiently widespread that they appear intended to wipe out or deplete the civilian population through a range of measures. Violations of the rules of war, that is, the principles I mentioned, proportionality, distinction, and precaution, can provide evidence that meet this element. Israel's attacks are noteworthy for their non-discriminatory character, both intentional and negligent targeting of civilians and civilian infrastructure through the widespread use of dumb bombs, such as 2,000-pound bombs in densely populated civilian areas, and directly targeting civilian areas with knowledge that there would be massive civilian casualties. Between October 7th and November 19th of this year, October 7th of last year and November 19th of this year, Israel has killed at least 44,000 Palestinians and injured over 104,000, of which 14,000 have been children. Over 10,000 are missing, presumably buried under rubble, and over 40% of those killed have been children, wiping out a large proportion of the next generation of Palestinians. More children were killed in the first 4 months of the war in Gaza than have been killed in the world's conflicts in the last 4 years. In the 200 days after October 7, Israel dropped an estimated 70,000 tons of explosives on the over 2 million Palestinians in Gaza, and these are more explosives than were dropped in Vietnam during the entire war there. Deliberate targeting of protected persons are also war crimes and evidence of genocide. Israeli forces have killed Palestinians regardless of their status as protected persons under humanitarian law. As of November 19th, Israel has killed 180 journalists and media workers, despite their wearing marked jackets and helmets or traveling in marked press vehicles. According to the Committee to Protect Journalists, Israel's bombardment of Gaza has been the deadliest conflict for journalists ever recorded. Also, as of the latest figures, Israeli military forces have killed at least 1,047 doctors and health workers, as well as 333 aid workers. Israeli forces have killed at least 247 UNRWA and other UN staff, which the UN states is an unprecedented number of UN personnel killed in history in a single conflict. Another element of genocide that is important in this case is the deliberate imposition of conditions of life designed to bring about the group's physical destruction. For this, evidence to be considered is the massive destruction of civilian infrastructure and essential goods and services to ensure the survival of Palestinians in Gaza. Israel has destroyed or damaged approximately 87% of Gaza's homes and residential structures. The Israeli army has targeted homes, hospitals, refugee camps, UN schools, and UNRWA facilities, destroying entire buildings where civilians have been sheltering. Israeli military forces have opened fire into crowds of people trying to get food from aid trucks and launched airstrikes on hospitals and hospital compounds where thousands of civilians were sheltering and patients and medical staff were housed. Israel has deprived Palestinians in Gaza of necessities for survival since October 7th of 2023. The entire population of Gaza, about 2.17 million, face high levels of acute food insecurity, and 91% of Palestinians are experiencing catastrophic hunger due to Israel's siege and deprivation of food, water, and necessities. The Israeli policy of continuously blocking fuel entry into Gaza has exacerbated the dire food and water shortages. The lack of fuel has caused the shutdown of bakeries, water desalination plants, wells, hospitals, and other key facilities necessary for survival. The survival of Palestinians and their flourishing as a people also depends on the survival of their institutions. UN independent human rights experts report that 87% of Gazan schools have been damaged or destroyed. The destruction of schools has left close to 700,000 students without access to education for more than a year. Israel has destroyed every university in Gaza, blowing up the last of Gaza's universities on January 17th, 2024. Israel has damaged or destroyed key civilian infrastructure needed for the maintenance of civil, educational, and cultural life in Gaza, including around 200 heritage sites. Among the destroyed structures are Gaza City's main public library, its central archive, holding a huge collection of historical documents, many, if not most, of the cultural centers and museums, and 227 mosques, one dating to the 5th century, as well as 3 historic churches. So what I've highlighted is just a snapshot of the extensive evidence presented to the ICJ by the South Africa team and in the report I mentioned by the human rights clinics. What the evidence reflects is that the key elements of genocide have been met, easily fitting the ICJ, the ICC, and other international precedents that have ruled on these elements in earlier cases. Let me stop there and look forward to the Q&A.
Thank you so much, Professor Akram. We now turn to our Q&A, and I see there's only one person who posted in the Q&A box, but a lot has been posted on the chat. So I'm going to try and, to one extent, try and fit some of the questions into that is taking a certain line into a question. I hope I summarize it correctly. I think one line of questioning that is coming through is a question about the value of international law, because a lot of the participants seem to say, and what we see is that over the past year, international law just hasn't had any impact. It seems the powerful will do what they want to do, and there's little that can be done by that. Now, in your areas, and maybe Professor Akram, in your work with students on international advocacy and on this issue, where the political establishment, especially in the United States, is not open to change in its support for Israel, what do you say to your students who may have lost hope in international law? You know, and what are the strategies that you can propose for international advocacy on Gaza?
Yes, we, of course, talk about this. My students have this question every single year, every single semester. And because we're engaged in Palestinian work, we talk about this all the time. And my response is that the fault is not so much in the law. It is, one, in the political framework that we are living in currently, and two, in the way that the great powers rigged basically the enforcement mechanisms of the United Nations, having only 5 countries be able to determine who lives and who dies in this world. And that our task is not only to strengthen the law through our work and our advocacy, but also to, over the long term, force change in the political structures that are preventing the law from being implemented. The law is just a tool, and it is one tool amongst many that activists and people of conscience have to change the system so that justice means justice for everyone, not just for those whom the powerful choose should have it.
Anybody else who wants to respond? Katarina, I know you in international law as well, so you're welcome to make a contribution on this.
No, I had a question, if I may, because I actually wrote it in the chat, and thanks a lot for all the presentations. It was a delight to listen to them. But what can we do to support the work of the 2 courts? Because we know that the pressure is enormous and it is not likely to decrease. On the contrary, so do you have ideas how I think we all who are here want to want the law to prevail after this, like Professor Akram described, all the destruction that has been made, archives, mosques, churches, and so forth. So we want the law to prevail. But do you have any advice how to help the courts not only to be able to work, but to conserve their independence? Because that's one key quality for a court of law, to be independent. So I'd be curious to hear your thoughts. Thank you.
You want me to answer this, or?
Yes, sure.
I mean, I think I'd be interested to hear what Professor Akram thinks. But in my view, the courts have shown their independence. Both the International Court of Justice in its recent advisory opinion, and as well as the pretrial chamber last week unanimously came out supporting the request for warrants, following the advice, or following the request from the Office of the Prosecutor. Of course, the ICC in particular has been subject to enormous pressure, threats, intimidation, etc. But it hasn't stopped them from doing their work. There was again a big delay with the issue of warrants. Countries coming in at the last minute, trying to delay things, change of personnel in the which was never explained in the chamber. But at the end of the day, they were unanimous. They came out. They knew they'd be widely criticized and condemned, but it didn't stop them. So I think the courts are showing independence. but it's the politics surrounding it. The problem, as Professor Akram said, it's not the law as such, which is a tool. It's the enforcement. It's the political organs where the problems begin, if you like, because to enforce the law, you have to rely on states and the political organs of the United Nations. And if they're divided, as they are divided, it's very hard to do that. Having said that, I mean, there may be something illustrative from the historical experience of the challenge fighting apartheid in Southern Africa, where the political organs were also divided. And so what you had there is a group of third world states or developing global South states coming together and creating special institutions to support the boycott, divestment, sanctions movement. You had civil society working within these states to bring change to the world, and I guess that's something that's going to have to be the same for Palestine, because we clearly can't rely on the traditional political structures which have failed repeatedly and continue to do so.
I might just add briefly to that I think because of these watershed decisions that have come out of the ICJ and now the warrants from the ICC, I think the work has now moved to civil society, because these are tremendous foundations and also powerful tools for civil society across the world to now build on in their domestic activism. And we are seeing that everywhere. There is nothing blocking, for example, Indonesia, Malaysia, South Africa, from bringing their own domestic prosecutions against individual Israeli perpetrators, from placing sanctions on settler leaders. There's something called the Global Magnitsky Act, of which over 30 countries are parties to Global Magnitsky sanctions agreements, where domestically they can bring sanctions against individual people who are war criminals, perpetrators of massive human rights violations. And the majority of Magnitsky sanctions that have been brought so far, especially in Canada, have been brought because of civil society has submitted the evidence to their governments. So there are, and this is just one example, there are many, many tools now available to build on what the courts have done for us.
Yeah, there's also a number of questions relating to anti-Semitism. The ones that struck me, and I'll just read it, it's to Professor Friedman, and the person asks, aren't we certain the historical context of anti-Semitism influences the interpretation of critiques against Israel? And can historical instances of anti-Semitism be conflated with contemporary critiques of Israel's policy? And there's also one from Yoshiko Kurita, a question, is it relevant to use the term new anti-Semitism? It's quite short, so I hope you understand that question for Friedman.
Yeah, just to throw my tuppence worth into the previous discussion, which I was avoiding because I'm a card-carrying non-lawyer. I think as a non-lawyer, it occurs to, and I think Professor Akram makes a very valid point. One of my fields of study over the years has been the way change happens, and legal judgments can be a very useful resource for people fighting for change and for a more equal world. But you also always have to regard that, they're a means to an end. If we sit back and simply wait for them to be implemented, they will never be implemented. We have to work in order to get them implemented. And for my fellow South Africans, I mean, just one point to illustrate this, because in theory, we're in an environment where a lot of this is easy. There's been some publicity over the last while or so about at least one South African, but I think there are others, serving in the Israeli military, which is an offense in South African law. You can't go and serve in another country's army. There's a specific law that deals with that. And some years ago, I and a colleague tried very hard with the help of a lawyer, to try to get the police to take interest in people who were recruiting for the Israeli army, and we didn't get very far. But I think the reason we didn't get very far is that there wasn't public pressure. There wasn't a public movement saying, look, this is not acceptable for South Africans to go and kill Palestinians. So that's just one example. Let me turn to the questions. Look, I think it's very important to stress that, the new anti-Semitism, let me use blunt academic language, the new anti-Semitism is a fraud. It's not anti-Semitism at all. The term new anti-Semitism is an attempt to say, well, if, as I indicated in my talk, if you dare to criticize the Israeli state, then you're a racist who hates Jewish people, which is clearly false. So I think that we ought to be concerned if the question is saying, should we worry about this? Yes, absolutely, we should worry about this, because as I indicated, besides the fact that it's spurious, it's being used as we speak to shut down free speech, to shut down the right to basic rights, a boycott, which is vilified in several Western countries. I mean, what is a more basic democratic right than the right to not consume various products or not associate with anybody you don't want to associate with? They can't, I think even very narrow definitions of democracy would include that. So I think we need to see it as a threat, but I certainly wouldn't want to give it any credibility at all, because it has none. The question of, it's a very interesting question, this question of the role of the history of anti-Semitism in this. And I've been thinking about this quite a lot over the last year or so, etc. And I think what is at stake here is, it applies particularly to Germany, but not only to Germany, is that we're told that the reason why countries like Germany, but certain other Western countries as well, are so uncritical in their support for the Israeli state and so hostile to anybody who dares to question it, is because they're racked with guilt because of the Nazi genocide. And quite frankly, I'm less inclined to believe that than I was a while ago, because particularly in Germany, because Germany is the kind of epicenter of this, the more I look at it, it's just the old racism with a new victim, basically. I mean, what used to be directed at Jews is now directed at Muslims and Palestinians and Arabs and people of Middle Eastern extraction who are identified, as I said earlier, identified as the enemy, driven out of jobs in the most absurd of circumstances. There was a young woman who was working as a journalist, a young Palestinian woman who was working in Germany, who lost her job for anti-Semitism because she posted on Facebook that there wasn't enough free speech in Europe, which was considered an anti-Semitic statement, because of course the implication was that she wanted freedom to express Palestinian aspirations. So it's used as an excuse. And of course, as I mentioned in the case of the British Labour Party, it is so tied up with Westernness rather than concern for Jewish people, that even in Germany, Jewish people are very often the first victims. There are Jewish anti-Zionist groups in Germany who are subject to quite serious repression. And one, he's actually Israeli, now lives in Germany. I mean, he put it, I think, superbly, although it would offend a lot of people. And he said, he found it obscene that the children and grandchildren of concentration camp commandants should be lecturing anti-Zionist Jews on how to be Jewish. But that is, in fact, what is happening in the world today. And I think we've got to call it out for what it is. I mean, racism against Jewish, I mean, I'm Jewish myself. I don't want to be the victim of racism. Anti-Jewish racism is unacceptable as any other sort of racism. But to use that, to weaponize that in order to mask the same sort of racism directed at Palestinians is obviously something which we find unacceptable. So, I think that increasingly it's an explanation which is used to make a rather ugly prejudice sound more acceptable than it really is.
I have a question here, and it's to each panelist. It says, please, can you speak of the situation and the struggles towards Palestinian liberation and ending complicity at the institutions you work at? At UWC, we have a strong student association and broad active solidarity coalition, which contributed to 2 progressive resolutions being ratified by our University Council in 2024. Also, to the event organizers, it's jumped for me, but it basically asks the question, why is it webinar on Gaza and not webinar on Palestine? So I think I'll think about the question for us and I'll let you go ahead. So anybody can respond. So I would really like to know whether your institutions has made any statements in solidarity with Palestine or condemning the Israeli response, and if not, what is happening there? What is blocking such activities? And we can start with Prof. Katan.
Thank you. So I'm at the University of Nottingham, so I have to be a bit careful what I say, I guess. But there has been no, I can say publicly, there has been no statement expressing solidarity with the people of Palestine. There was a kind of bland statement that was issued after October the 7th, kind of like written in a way that could not upset anyone. The university, I think that's public knowledge, has long-standing links with the arms industry because we are in the East Midlands, and one of our BAE Systems, which is a big arms company, biggest arms company in the UK, Rolls-Royce is another big, they don't just do weapons, but they do make engines and missiles and nuclear submarines and things like that. They are a big employer here. They're headquartered in Derby, which is just down the road from Nottingham. A lot of our students find employment there. And there are strong institutional links between these companies and my university. We had an encampment. They took over. They put an encampment just outside the engineering block, but the university went to the courts and got them evicted. There is a trade union. We have a trade union here. They're just. I don't know if this is public. Is this being recorded or limits what I can say? Okay, well, there is going to be some movement on this, but it's not public yet. I think in the next few days there'll be a statement issued so obviously from the academic side and the student side, there is a lot of anger towards the position taken by the university. I should also mention, and this comes perhaps to what Professor Stephen Friedman, and I think one of the other questions raised, the context of the Labour Party in this country. I was overseas, fortunately, for most of the tribulations, but the universities were forced to adopt a definition of anti-Semitism, the IHRA definition of anti-Semitism. And my university has also adopted this, and it's on its website. And initially, when they adopted it, they adopted the definition with its examples. And the examples given on the website included, for example, describing the state of Israel as a racist endeavor. So this made it very difficult to organize events, as I discovered to my detriment. Where on apartheid, for instance, topic of apartheid, can apartheid apply beyond Southern Africa to the situation in Israel and Palestine? I won't go into all the details as I wrote about this, but it created a lot of difficulty. We eventually were able to have our event, but it wasn't very easy. So basically universities have all these pressures on them. There's interest groups that there's an organization called UK Lawyers for Israel that scares university administrators into silence. They're very effective. They're very active. They're very forthright. And so that's kind of the context, I think, a little bit of the context in which we're operating, and makes it difficult to discuss topics like Palestinian liberation, but some of us continue to do so regardless.
Thank you, Prof. Friedman.
Yeah, look, some South African universities have made statements, and there has been pressure after they've made the statement. So the University of Cape Town, which I'm quite aware of, did. I think Senate and Council adopted a resolution, and I gather that there is huge amount of pressure, but so far they haven't receded. It varies from university to university. I mean, at UJ, there has been an intense lobby to try to get the university to take a much stronger stand, which has had limited success. In fact, we've gone backwards to a certain extent at UJ. I was part of an initiative at UJ some years ago in which we successfully persuaded the Senate to cut links with any Israeli university which could be demonstrated to be assisting the occupation or assisting the discrimination against the Palestinian people, which incidentally, if you look at the evidence, is all Israeli universities. So in effect, there are individual contacts, but UJ cannot enter into any cooperation agreements with Israeli universities. But it's not enough, which I think is what the questioner is suggesting. I would agree with that. It's not through want of trying. People are trying very hard. And the reason are much as Professor Katan has said. I mean, it's not only donors play a role, not as huge a role as they play in the US, where they play a massive role, but they do play a role. And it's more than just the donors. It's who university bureaucrats associate with. It's it's who invites who to social functions, etc. All of that plays a role. And then finally, what often plays a role, and this is true of media, etc., which I think Professor Katan also hinted at, is if you're an administrator or whatever, you want to get on with what you're doing. And if a bunch of very militant people, very loud and aggressive and bullying people who are looking after the interests of the Israeli state are going to badger you whenever your institution takes the position that it should take, you're going to prefer the quiet life. And I think that happens quite often. So, it's not that they're in the pockets of anybody necessarily. It's just that they look at this and they say, it's not, when they get pressurized, it's just not worth the effort. So it's an uphill battle even here. And the environment here is obviously, I mean, no South African unit, I deal in my book with the IHRA definition at some length, which, does, as Professor Katan says, mean that, if you take a moral position in support of Palestinians, you're an anti-Semite and you're breaking the law. Fortunately, we don't have that, but we do have a lot of foot dragging and a lot of responsibility dodging, and we continue to do what we can to pressurize them to do more.
And Professor Akram?
Yes, well, I'm sure you're all aware of the hotbed of protests and demonstrations on campuses here in the United States. And of course, in Boston, we are in a very compact environment with 80 universities and colleges in a fairly small area. We've had encampments at almost all of the universities, not at Boston University, primarily because BU is in the heart of the city. And so it's very difficult to have an encampment that isn't going to be basically broken up because it's disrupting the flow of traffic in town. But the students have shut down one of the bridges between Boston and Cambridge. All of the encampments at the major universities, MIT, Harvard, Emerson, have been very violently disrupted, and students placed under both criminal proceedings and under disciplinary proceedings in their universities. And our students, because we haven't had a campus, have been at all of the other demonstrations. I've gone to the encampments at the other universities and found all, my students there. And so they've been arrested. So what faculty and staff have been doing is organizing to defend our students. And that's taken a huge amount of energy and time and effort. So far at BU, we've gotten every one of our students off. mercifully, but that's not been the case at other institutions. A dozen Harvard students were prevented from walking in their commencements and getting their diplomas. Those cases are still ongoing. So students are paying an extremely high price, and not only students, faculty as well, who have lost positions, had classes taken away from them from teaching, had raises overturned. And of course, I'm sure you know that as a result of the hearings in Congress of several of the university presidents, 2 university presidents resigned. So the pressure is intense. I am utterly in awe of our students here across the campuses. They seem to be unafraid, even though they're being doxxed. There was a truck around Harvard with the photographs and personal information, contact information of the student leaders of the encampment, basically creating a hit list for anyone who wanted to go after them. So students have been really taking their careers and their safety, putting their careers and safety at risk in doing this work, but they haven't stopped. So it's quite incredible.
Yeah. Thank you. There's also some questions coming in on the one on the chat box, for example, says, is Israel really a state without borders, a state without a constitution? Is it not a state of Palestine from the river to the sea, one democratic state of Palestine for all who live in it? And just on that, in terms of what we can do in our countries, and what has been done in other countries is to pressure for recognition of Palestine, but that would not be disrecognition of Israel. So it's almost forcing a two-state solution when I think many people do not feel that that's the optimum solution. And just in terms of international law, there's also a question regarding the application of the concept of apartheid to a system where there's essentially 2 different states. Is it the same as, can you apply apartheid to this situation where it's the two different political units? So I'm throwing all of that in one basket, but you can dissect what you would like to respond to.
Who do you want to go first?
Yes, Victor,
Me?
please.
Okay, yeah, you can apply apartheid to a different political unit. That's what happened in Southwest Africa, Namibia, where legislation of South Africa was extended to. Same thing between Israel and occupied Palestine, where Israeli law, the law of the Knesset, judicial decisions or Israeli law channels through military orders are applied to Israelis in the West Bank. So it's personal status. It doesn't apply to Palestinians, but so they're extending their law to individuals who hold a particular ID card. So it is there is some similarity there. The one state, two state thing is a bit tricky. I mean, in international law, a state doesn't have to have finalized borders to be a state. Israel is often given as the example. There are other examples. I mean, I don't want to spend too much time on this. You'd have to go back to the history of the UN partition plan. But I guess to answer it in a short way, you effectively have a de facto a one state what my former boss Dr. Saib Erekat used to call the one state reality. Whereas, de facto Israel controls everything between the Mediterranean Sea and the Jordan River, and it is effectively one regime, and that regime is oppressive for all the Palestinians who live under it. And if you try to abolish the argument is if you try to abolish the idea of a Palestinian state, you're just accepting that regime. And so the idea of a two-state solution, it isn't, as I understand it, necessarily an idea of hard borders, but it would be different spheres of sovereignty, and Palestinians would govern themselves and Israelis would govern themselves. It's become much more difficult now because of the settlements. The ICJ has basically said they're all illegal and they have to be uprooted and removed. It might sound far-fetched, but this is what happened in other colonial situations in Algeria. The Israelis, the lot smaller, the settlements in the Sinai Peninsula, but after they had peace with Egypt, the settlers and the settlements were removed from the Sinai. It's obviously more complicated in the West Bank, but there can be creative ways if people want to put their mind to it, but there's no appetite for that at the moment. And on the contrary, the Greater Israel Project's never been more powerful than ever. And to the extent that we're now seeing mass displacement, killing, and perhaps new settlements being established in North Gaza.
And anyone else wants to comment on that?
Well, just to point out, I mean, I don't know whether the question is aware of this. I mean, this country has recognized Palestine for years. I mean, if you go to discussions on Palestine at Durka, at the Foreign Ministry, the Palestinian ambassador is usually there. I mean, we've had a Palestinian ambassador here for a long time. And just an interesting sort of insight, which, I pointed out in the article I wrote, which a lot of people don't seem aware of. One of the reasons why South Africa got involved in the ICJ case was because of the links between the ANC and Fatah, basically, which currently controls the Palestine Authority. So I mean, it was always quite funny when the Americans politicians used to go on about how South Africa was doing Hamas's bidding. I mean, basically, there's no relationship between the ANC and Hamas. There's a long-standing relationship between, dating back to Yasser Arafat's time, etc. And look, the question of one state or two states. I mean, I've always been identified with a one-state position, but I mean, I think that given what is happening in Palestine, the attitude I would take is that there needs to be a negotiated settlement which produces democracy and rights for everybody, and to start dictating. You can't on the one hand say people ought to negotiate the future, and then on the other hand tell them what they have to negotiate. I think, to me, the problem with the two-state thing at the moment is not only that it's used as an excuse for inaction, but that it basically says, well, yes, of course there should be a negotiated settlement, but you can only come up with the following outcome, which doesn't really make it. It would have been like telling South Africans that we can have a negotiated settlement as long as we endorse Bantustanis. So I think that's the point that's got to be made, that you can't accept a negotiated settlement and then tell people what they have to negotiate.
Maybe I could just add a couple of points. One is that, of course, the majority of countries have now recognized Palestine as a state. And in 2012, the General Assembly voted that Palestine was a state. At the same time, of course, in 1947, March 1948, Israel was recognized as a state. And so we have that. One of the most important aspects of statehood is recognition by other states. So we have that on both sides. And on both sides, we have the questions of who is the population, what is the territory, where are the borders. So I think on both sides, some of those questions are unanswered. And yet we have majority recognition of two states. The other point I want to make is that for me, it's less of a question of the character of the territory or statehood than it is, are we going to be driven by justice? And if we're going to be driven by justice, the questions and the answers change, because international law now is quite clear that justice for Palestinians means return, restitution, and compensation. That's what Resolution 194 has incorporated in its paragraph 11. And that resolution has a very unique character in international law. It is the only resolution that has been reaffirmed every single year since its passage in 1948. And so we know what justice must look like. And therefore, if that can be achieved in a single state, in two states, in some sort of confederation, to my mind, it doesn't matter, because the outcome is justice. Can Palestinians, all Palestinians who want to, return home and get restitution of their properties in a two-state solution? What that means is their original homes, their areas in their original, in their places of origin, not Palestine as another state from where they did not come. So again, what drives the question? Is it a drive for justice? Then we know what that means. And the resolution looks different.
Yeah. Thank you. I'd like to refer to one of Katarina's questions, where she says, do you see any chance that some elements of the Israeli society could bring about any change to Israel's behavior due to these serious violations of international law? But with that, I want to also pose a question from my experience as a South African with justice, where there was justice, yes, but there was also a reconciliation process. Now, with 44,000 people dead, I think that process will be quite tough. So just your views on that and Israeli society. Yes. And anyone can go first.
Yeah, let me just say that, yeah, okay, the first question is Jewish Israeli society. I think, I'm struck by having lived through, having experienced both. I've observed the one and lived through the other. I mean, it's not that much different to white South Africa under apartheid, quite frankly. I think, about 95% of whites supported apartheid, but there was a vocal 5% who saw that it was wrong. And I think that's the reality with Jewish Israelis, and I don't see that changing anytime soon. But there is an aspect to this conflict which I think is very important, which is going to become very important over the next few years. And that is, you have to distinguish between Jewish Israelis and Jewish people elsewhere in the world. And obviously, Jewish people elsewhere in the world are not, they don't have a veto over what happens, but they're a voice in what happens. And in contrast to Jewish Israelis, Jewish people elsewhere in the world, do not have their personal futures don't depend on this, if I can put it this way. I mean, like white South Africans, if you're a Jewish Israeli, you have all sorts of privileges at the expense of Palestinians. You've got very comfortable living on other people's land, etc., and you're not really open to changing your mind. But if you're Jewish and you live in upstate New York, or in Nottingham, or in Paris, your daily life is not really affected by what happens to the Israeli state, quite frankly. You get on with what you were doing, whatever happens to the Israeli state. And I believe that we are I think that we've already started a process. I wrote a piece shortly after October the 7th in which I said that I thought that October the 7th was Israel's Sharpeville. And by that I meant that just as Sharpeville, we tend to forget that before Sharpeville, there wasn't that much international pressure from citizens on apartheid. But after Sharpeville, the international anti-apartheid movement really took off. And I think it's going to be the same here. I think that you're increasingly finding that citizens of a variety of walks of life, it's going to, I mean, I predict that in the next few years, among many people in many parts of the world, it's just going to be unacceptable behavior to buy Israeli goods, to associate with the Israeli state in any way. And I think that there's a lot of potential in that for Jewish people in other parts of the world to play a major role in that, precisely because you don't have this baggage of trying to persuade people that they should give up privileges which they've enjoyed for generations. So I don't have very high hopes for persuading Jewish Israelis, but I think we've already seen over the last year a huge shift in Jewish opinion, particularly among younger people, which is obviously very encouraging for those of us who approve of the shift. And I think watch this space. I think this is going to be an important part of the pressure for a just settlement in the years to come.
Anyone else?
Agree with that, and just to build on a couple of points. One is that here in the U.S., the protest movement is being led by the Jewish community, Jewish students, Jewish progressives, Jewish radicals. They are at the forefront here in the United States. It's Jewish Voice for Peace that brought business to a halt on Wall Street, that has been occupying Congress, and is a huge reason why, for the very first time in history, 19 senators supported a bill to stop arms to Israel. We've never seen that before. And that's because of the activism of their Jewish constituents more than anyone else, because the Arab and Muslim community is not nearly as organized. It has only made its presence felt in this last Democratic convention through the uncommitted movement, which of course now the Democrats are blaming them for having lost the election. That's not the case, but in any event, the voices of the sort of organized Arab and Muslim groups have made very little difference in US politics, certainly nothing compared to what the Jewish community now has done in supporting Palestinian cause. The other point I wanted to make about Israeli society is simply to say that the powerful never give up power willingly. We don't have historical precedent for that. The only way that things are going to change is massive pressure on Israel. And that is and prosecutions, frankly, prosecutions of people both at the top and, for example, Israeli soldiers who have been boasting about their war crimes. And I think that is also happening. Sanctions that make life difficult for Israelis. We already know that thousands of Israelis have left and are using their second passports to leave the country. Now, presumably many of them are the Israeli left, which is a shame, but they will also join the opposition outside of Israel to bring justice about. And the last point I want to make is that there's no such thing as peace without justice. If people's grievances continue generation to generation, we know that violence and resistance will continue generation to generation.
Thanks. There are 4 questions to, I think, Professor Friedman. And it's around, the first is, are there any legal or constitutional definitions of the concepts of Jewishness or what it means to be a Jew or Jewish? I'm presuming that is in Israel. Are there any legal or constitutional definitions of the concept anti-Semitism? Who developed, ratified, and adopted these definitions? And where are they applicable and enforceable, and by whom? And lastly, are there any other similar legally protected categories specific to a particular so-called people group, what, if any, is the president? So I mean, choose, or you can take them all together.
Okay, I mean, does the Israeli state have a definition of Jewishness? That is a huge, within Israeli Jewish society, that is a huge area of controversy which has been going on for years, which has to do with a whole lot of arcane religious stuff. I mean, basically, there's the standard definition in your law, in their law, is that you are Jewish if your mother is Jewish or if you converted to Judaism. And the argument is that the various denominations, the more traditional observant types say that only they can convert people, and the more liberal groups say that they're entitled to convert. But it's not only is there a definition, but in fact, for example, in Israeli, if you look at an Israeli passport, it doesn't give citizenship. It doesn't say Israeli citizen. It gives nationality. And nationality will either be Jewish or Arab, quote unquote, or whatever. And in fact, a Jewish Israeli, one of the 5%, went to court some years ago and said he wanted his passport, he wanted to be described as an Israeli in the passport, not as Jewish. And the court rejected that. We don't do that here. So there's not even, I mean, so entrenched are the racial definitions that there's not even a sense of common citizenship. As far as definitions of anti-Semitism is concerned, well, Professor Katan talked about that to a certain extent. What is happening at the moment is that there's this IHRA, which is the International Holocaust Remembrance Alliance, which is actually it's an alliance of Western states. It was actually started by the then Swedish Prime Minister. And ostensibly, it's supposed to remember the Nazi genocide, but in fact, what it has become is a sort of police force for the Israeli state, because, as he pointed out, they have this definition, and I talk in my book about the controversy of the definition. But essentially, they've interpreted to mean that if you criticize the Israeli state, you're anti-Semitic. So that's their definition. But there are other definitions, and the definition which is usually quoted nowadays in contrast to that was adopted a couple of years ago in response to the IHRA definition, and it's something called the Jerusalem Declaration on Anti-Semitism. And this is a declaration signed by a very large number of Jewish studies scholars and Holocaust scholars and genocide scholars. So, I mean, people who are academics who have been working on these issues for many years. And essentially, it offers a definition of anti-Semitism which does not criminalize opposition to the Israeli state, which goes back to what some of us would argue the definition really is, which is racial hostility directed at people because they're Jewish. So there are several definitions, and which definition you accept, I guess, depends on where you stand politically at the moment.
Okay, so we've almost come to the end of our event, but I do want to give our panelists just an opportunity. If you have anything more on your mind or in your on your heart that you want to say, then speak now. Prof. Akram.
Yes, so I just want to reiterate how momentous the issuance of these warrants is. And even though what we know of them, since they're under seal, and all we know is based on the announcements from the pretrial chamber, we know they're for war crimes and crimes against humanity and don't include genocide. But as Professor Katan said, the prosecutor has made it clear that they are considering more potential charges. And I would add that some of the leaders of our countries should be very worried, because genocide by itself is not just is not the only crime. The complicity to genocide is also a separate crime. And any one of our leaders, like President Biden and Secretary of Defense Blinken, who have given the green light, provided billions and billions of dollars and massive amounts of weaponry, including those 2,000 bunker buster bombs that I mentioned. They are also, they should also be very worried about more charges coming down. And I think perhaps this is going to be a sea change in the way international law both is implemented and is going to be perceived around the world. Perhaps we are moving to a new era where we're going to see even-handed justice.
Thanks. And Professor Katan?
Well, I like what I'm hearing, but I'm going to be the doomster, I'm afraid. I'm yeah, very skeptical about. I mean, I'm happy, obviously, that these warrants have been issued, and I hope there'll be more. But with the imminent inauguration of Donald Trump as president, divisions in the Arab world, the suppression of student protests, I think we've got a lot of work still ahead of us. Yeah, I'm hoping that with arrest warrants, the G7 is supposed to come out with some kind of statement about how they're going to react to it. It'll be interesting to see that. But again, warrants needs cooperation amongst states. We've already had some governments come out and say they're not going to respect what the court says. They're not. I think the president of Hungary has actually invited Netanyahu for a state visit. I think the German government has not said anything helpful. The UK is on the fence. So the various concerns I have, but generally speaking, the courts are doing their job and they're going in the right direction. I'm just concerned about what governments are doing, and I guess the only way to change that is by public pressure and civil society. But we're going into an era where the US is going to be very hostile to all these developments, at least for the next 4 years, and we've got to think about how we manage that, because that's the reality we're facing.
And Professor Friedman?
Yeah, I think both my fellow panelists are right, quite frankly. I think that it is important, but I think that it's right to say that there will be lots of obstacles. And I think to sort of try and bridge the two positions, it's important for us to see this. It's not a magic bullet. It is a resource for people who are concerned about justice, and the impact of this ICC decision will really depend on how people who do care about justice use it effectively over the next few years to hold the Israeli state to account. Thanks.
Yeah. Katarina, do you want to add anything?
Thank you. Just thank you. And one thing that I think this is a watershed moment. Like the panelists said, this is very important, but we have to work so that we can get there. What Professor Akram was saying, a society based on law and justice. So there is a lot of work to be done. Thank you.
Thank you so much. So again, I'd like to thank all the speakers for engaging with us on this topic. I've certainly learned a lot, and I'm sure our audience did as well. And I also want to thank Professor Nola Dippenaar, who is the president of the South African National Pugwash Group, for all her support for this event, and especially Katarina and the Finnish Pugwash Group for coming on board and supporting this event. And then finally, I'd like to thank Melody Williams and Zakira Green, who helped us with the technical side of this webinar. And with that, I wish you a good evening.
Thank you.
Thank you very much, and good afternoon from Nottingham.
Bye-bye.
Thank you. Bye-bye.
Bye-bye.